Writing persuasive briefs. Today's lecture is two parts. First, a quick overview of the multi-state performance test, or the MPT. Then second, an introduction to one of the most popular forms of U.S. legal writing that you'll need to learn for the MPT, persuasive briefs. So we'll cover first, quickly, what the MPT requires from you in terms of reading and writing skills. Then we'll compare and contrast persuasive briefs to objective memos, and then look more carefully at the structure and the parts of a brief, as well as the importance of headings in briefs, and how IRAC gets used. Finally, we'll put this into action by looking more deeply at one of the sections in the argument of the brief you read for this week by the defendants in Capital One. Okay, so what is the MPT? It is two 90-minute sections of the Uniform Bar Exam, and they count together for 20% of your bar score. And in that 90-minute period, you have a lot of things to read, including an instruction memo, usually from a lawyer, case file materials, and these are kind of like the case study materials we've used for co-works. And then fictional materials that describe the law, but in a simplified way. And with all that, you have to write a legal document, which is often an objective memo or a persuasive brief. So what are the reading skills you have to hone for the MPT? Identifying relevant facts is probably the most important thing. And unlike law school classes, you're not getting these from a single fact pattern. You're getting them from multiple documents. The word of caution is that the UBA tells you that not everything is equally important in those facts. Part of your job as a lawyer is to weed out the relevant from the irrelevant. Secondly, of course, you have to understand legal principles. But the nice thing about the MPT is actually the rules here are not really meant to be challenging. The rules are simple. It's really more how you apply the rules to your facts that's challenging. That's where all of the effort is on the MPT. And finally, as you know, you have to read quickly. On the writing side, it's pretty similar. The most important thing to know is that you're writing on behalf of or to actual clients. So you're writing briefs, memos, maybe a letter or demand letter. You're not writing law school essay exams. And of course, you're spending a lot of time then applying the legal rules to your own client's case facts. And of course, writing quickly as well. We will spend a lot of time on this final point, headings and captions, because these are incredibly important for the sort of quick writing that you're doing for the MPT. All right, so taking a bit more focus on the brief writing component. Again, it's one of the most common types of assignments you get in the MPT. And the good news is usually it's just the argument section of the brief. So not the facts, not all the other pieces of the brief. And good to know is that the briefs are always in tandem with something else. You're not always reading those other motions, but just know that the brief is all of the reasoning in support of the motion. So here are a couple of examples of the types of motions that you might be asked to write about. You don't need to know all of the ins and outs of that, but it is good to know that they could be various. Okay, so how can you succeed? A big part of it is this semester working hard on your writing on these different aspects of it so that you feel comfortable. And then, of course, over the summer, spending time working consistently with your bar review course. So let's get into it then. One way to figure out what persuasive briefs is all about is to compare them to objective memos. The audience for a memo is always an attorney or a client, whereas the audience for persuasive brief is always some kind of a court. It's okay, though, to address that court directly, and we'll talk about that more later. Now, the stance in an objective memo is neutral. You're trying to be objective and honest. You have to be honest as well when you're writing a persuasive brief, but you are writing as an advocate, which means that you can highlight things that are more favorable for your side while still bringing up the things that are negative, while trying to distinguish them, as we've talked about before in class. The tone and vocabulary are the same for both, so there's nothing really different there. On the memo side, you are trying to explain the law as it is. You're not asking for a change. On the other hand, in a brief, you are absolutely asking the court to do something very specific for your client, or to oppose something that's going to be done to you. And finally, in a memo, headings are relatively short and neutral, whereas in a brief, they are part of the argument. They are absolutely important to your brief. Then how do you structure a brief? Now, there will be variations across different courts and style practices, but when you are writing a trial level brief, you will always have the following sections. The introduction, which is really just the tip of that pyramid, 1 or 2 or 3 paragraphs at most. Then in many briefs, some kind of statement of facts or summary of facts. Now, most importantly for you, for the MPT, you're almost always going to be asked to focus just on the argument, where you're analyzing the legal issues, and you're going to structure that in a very organized way. And finally, a very short conclusion in most briefs, where you just ask for the relief that you want for your party. Okay, so the best way, I think, to understand the structure of a brief is to look at its headings. If you stripped out all the headings in your brief, it should create an absolute outline of your arguments. So here are the stripped out headings from the first part of the Capital One defendant's brief. Argument, section 1, that is very broad. That is simply a standard of review or standard of that the court must look at. And that's required, actually, in many briefs for summary judgment or some other kind of motion like that. Then, section 2, also pretty straightforward, right? Lots of short statements of rules. And that is fairly typical in briefs. You don't have to do it this way, but this is one way of doing it. If you don't front load your rules, then you would want to sprinkle them in throughout the rest of your brief and then elaborate on all those rules. So let's take a look at the next section. These are, again, just the headings from the next section in this brief. Section 3, actually. So what do we have here? We're going to look at this one and this one in more depth in just a minute. But you can see that these seem much longer. They are argumentative. They have conclusions. And then lots of detail, facts about the case. This is what you should be aspiring for, especially on the MPT when writing a brief. You want to show conclusions, and the conclusion should explain why we should win, which you can only really do if you contain case facts within those conclusion headings. So let's talk some more about how you do that heading. In a memo, you might say something like this: whether the non-competition provision, which is more of an issue statement. In a brief, you might say more like this, which is a conclusion. We're asking the court for something. In a memo, you might just be very short and plain and write that or that. Whereas in a brief, you're going to lay it all out there and tell the court exactly what it is you want the court to do. Now, this is long. This is probably about as long as you'll ever want to make a brief heading, but it does demonstrate something that the MPP examiners want to see. They want to see all the facts. And here's where all the facts come in. Without them, it's simply a conclusion. All right, so having seen the headers, where does IRAC figure in? How does that work in briefs? Here's a page from the brief that you've already looked at before that I've outlined with the IRAC proportions. But what I want to point out here is that the heading also is a conclusion. And I want you to see how they all work together. It doesn't always have to be in this exact order, but this was a pretty good one. A strong conclusion heading, followed by a strong conclusion topic sentence, followed by some application. If you needed to state the rule here, you could, but otherwise, it's good. And now you have a new section where you state a new rule. That works as well. All right, so let's pull this all together by looking at, in a more sustained way, one section of the brief, that same section 3. The beginning of that section. Broad statement, basically just 2 short sentences. This is pretty typical. You don't need a lot at the beginning, but it's often good to have a few sentences before you launch in to your section A. All you're asking for here is for judgment. And how do you know that? You use words like should be stricken. Summary judgment should be granted. Now, it may seem odd, but it is entirely appropriate to address the court in this way. This should happen, or this must happen. We ask for this to happen. That is very typical. Okay, how about this section, or the body of the section? Here is the middle that just follows what we just saw. And I'm not going to read all of this, but what I want to do is just point out the IRAC parts of it. This is obviously where you want to develop your reasoning and apply the law to your facts. So this first section is, again, a nice quick conclusion section. And then here's a rule. Even current employees have a right to do X, Y, and Z. And then this next paragraph is basically all application. Now, this is not the most artfully worded application section, but it starts to analyze and apply the law to the facts. And here are some words that you can use that signal that this is application. In this case, in the present case, in the instant case. Then also, the clause at issue here, the contract at issue here. All of these things work. Now, how about the end? The end also is generally short and sweet. That is all you need to do for the MPT and in most brief sections. So you are restating the main arguments that you've just made, and you're also restating what you're asking the court to do for you. In this case, asking that the non-compete covenant be struck down in its entirety. Now, I realize that this may sound like you're asking a lot of the court. You are yelling at the court, saying, do this, do that. That is appropriate, as long as it's respectful. And here are a couple of alternative ways you might do that. Defendants ask this court to do X, Y, Z. This court should hold that, ... Or this court should therefore grant defendant's motion for summary judgment. All of these are respectful, but are clearly asking the court to do something for your client. Okay, so let's sum up. In an argument section for an MPT, then, you want to start out with a short, sweet introduction. You want to use strong headings throughout that really signal where you're going with your argument and state your conclusions based on your client's facts. You want to apply your law to the facts as much as possible. And then finally wrap it up with a short conclusion in which you repeat why you should win and ask the court to grant your motion or oppose the other party's motion. And that's pretty much it. Now, I know that we've covered a lot of material and it may not seem very easy at this point, but with time and practice, I know it will feel much more natural.